Ladies and gentlemen, please take your seats. We will be starting momentarily. Thank you very much.
Good afternoon. My name is Natalie Turvey. I'm Executive Director of the Canadian Journalism Foundation. On behalf of the CJF and CIPPIC, our partner for today's event, welcome to this half-day symposium, Striking the Balance, Privacy and Freedom of Expression in the Digital Age. We're delighted to welcome Privacy Commissioner Terrien, along with privacy experts, the tech industry and journalism thought leaders, to explore the implications of the right to be forgotten for Canada. At the heart of our debate, should Canada follow the European Union's 2014 ruling to give its citizens the right to ask search engines like Google to remove search results about them? What can we learn from the European experience about the trade-offs between a person's right to privacy on one hand and society's interest that the right to freedom of expression and information is preserved? And can we find a way to balance the two? It's a complex task with no easy answers. For the last 27 years, the Canadian Journalism Foundation has been a steady advocate for excellence in journalism. Our motto, "As journalism goes, so goes democracy," feels more relevant than ever as we navigate an increasingly complex news and information landscape. Right to be forgotten doesn't just affect search engines, it also has profound implications for journalists and newsrooms around issues of unpublishing and informed consent. So we look forward to delving into some of these issues this afternoon. I'd like to thank Google for making this event possible, and our thanks to our in-kind sponsor, Cision, and to CIPPIC, Canada's public affairs channel, for its broadcast of today's symposium. A bit of housekeeping. The hashtag for today's event is RTBF, if you'd like to join the conversation on Twitter. We will have back-to-back sessions this afternoon with only one break, so I apologize in advance that the introductions of our speakers will be woefully inadequate. They are outstanding, but you do have full bios in your program to consult. And before we get going, I'd like to share the results of a new poll we conducted with the support of Marrow Matchbox. We reached out to Canadians this week to get their thoughts on accessing lawful and accurate news stories via search engines, and we have the findings. The results reveal that 74% of adults believe Canadians' right to access news overrides the right to remove accurate and lawful stories that have a negative impact on a person's reputation. A more specific question involves removing a story if an individual is concerned about an accurate news story affecting his or her personal reputation. In that case, the public opinion was more polarized. 58% of those surveys believed a search engine should not be required to remove it, while 40% believed it should. And finally, as for those who should decide if a news story is removed from a search engine, 60% believe the court should make the final decision, while 23% believe it should be the role of news editors, 19% said the government, 18% said search engines, and another 18% said none should have the power. So something for us to noodle as we head into our sessions. You can access the full poll results and data on our website, cjf-fjc.ca. And now it's my pleasure to introduce David Fuhr, Director of CIPPIC, to say a few words.
I'd like to thank the Canadian Journalism Foundation for organizing this excellent event. I'm the director of CIPPIC, which is the University of Ottawa's Public Interest Technology Law Clinic. Our mandate is to intervene on behalf of the public interest at the intersection of law and technology. And so you can understand why our organization would take a keen interest in the Privacy Commissioner's proposal to implement the right to be forgotten in Canada. We view the right to be forgotten as bringing into conflict core values that are extremely important to Canadians. On the one hand, the right to be forgotten acknowledges reputation and privacy. It addresses the distorting effect that content featuring inaccurate, incomplete, and outdated personal information may have on reputation. And reputation and privacy rights at their heart are all about our constitutional values of dignity, autonomy, equality, integrity. But in defending reputation and privacy, the question is, has the Privacy Commissioner's proposal struck the right balance? Because on the other side of the balance is, of course, freedom of expression, which includes the right to access information. Now, the Office of the Privacy Commissioner's draft position on online reputation acknowledges this conflict, and hopefully today Commissioner Therrien will walk us through that. The draft position, to say it very briefly, includes provisions or suggestions that the right to request a search engine to de-index results with respect to a person's name that's inaccurate or outdated or incomplete. And in addition, the right to request content be taken down for similar reasons. But the draft position qualifies these rights, balances these rights with an acknowledgement of freedom of expression where matters are of the public interest. So those are some of the questions that we're going to explore today. Did the Office of the Privacy Commissioner get that balance right? Does the draft position skew too heavily towards reputation and privacy? Conversely, does it skew too heavily towards freedom of expression? Do the mechanisms proposed create more problems than they solve? Does PIPPIC, which is, after all, a commercial private sector privacy statute, even apply to search engines, which are a service provided to the public for free? I look forward to hearing our speakers' thoughts on these questions and others. Now, it's my privilege to introduce to you our first speaker, Amanda Maltby. Amanda is the is the General Manager, Compliance, and the Chief Privacy Officer for Canada Post Corporation. And she is the Canadian Marketing Association's she's on the Canadian Marketing Association's Board of Directors and chairs the CMA's Privacy and Data Advisory Committee. She will be speaking to us on how Canadians view digital privacy and transparency. Amanda.
Thanks, David, and it's a pleasure to be here this afternoon with everybody. Many thanks for the invitation. I must admit, when I looked at what I was asked to speak about, which is Canadians' attitudes towards privacy and transparency and sort of their digital lives, that's an awfully big topic. And I thought about it as it relates to when I received the invitation to the event and what's gone on in the past few weeks, and I could say that's changed probably dramatically in the minds of some Canadians. For some, they might view privacy as being fleeting. Others, where it is that they really think about what's happening to themselves in their digital lives, it's becoming more of a concern. What I'm going to talk about more specifically is some research that was commissioned by a group of chief privacy officers. We're the ones who are in large organizations, who are in the trenches, really trying to think about issues about privacy. Really about what does transparency mean as it relates to customers, clients, and also to citizens. Like all research, I'm going to say that the findings are really a moment in time. And I would say that it used to be around privacy that you could conduct opinion research, and the findings would be considered to be valid for some time. And as Natalie showed in her research, and also as I just mentioned, and as some of you are reporting through your daily stories and your opinion pieces, I think privacy has arrived. Based on those stories, and based on the technology, the steps and the missteps, Canadians' attitudes towards privacy are changing. And they need to be measured and considered like some of the broader, more societal issues that we see research conducted on more regularly. So, for instance, we used to see a lot of research done around the economy, around the environment. Privacy, we don't see as much of that measurement in terms of what Canadians are feeling about privacy and about their digital lives. Perhaps in the context of research and knowing what those attitudes are, it's important for organizations to really reach out and find out what is top of mind for citizens and consumers. The other thing I'll say about the findings is that they don't specifically speak to reputation and the so-called right to be forgotten, which is the main topic of the symposium this afternoon. But they do provide a big picture into the views and expectations about privacy and about transparency and what Canadians expect when they're interacting with organizations online. And they provide ideas on where companies need to move to, areas to do better, not just for marketing, but for general transactions that are based on the collection, use, and disclosure of their personal information. Simply put, I think that it's for organizations to take on the responsibility that comes with building data lakes, that comes with creating advanced algorithms that slice and dice consumer information. This is something that everybody's doing in this room. All of our organizations are doing this in this room. We think about it in terms of eyeballs and click-throughs and also purchases. This is something that the research really, we looked at and tried to provide some insight in terms of what we need to do within our organizations. And as privacy leaders in Canada, we wanted to know how to have the conversations within our organization. What are the changes that we need to put in place so we can move the transparency discussion forward in Canada. And quite frankly, too, we also wanted to answer the call from Commissioner Therrien, to seek solutions and self-regulation by industry. So what did the research tell us? And I think that the complete survey results were provided to you, and I'm just going to take you through some of the highlights of what we found in the findings. So perhaps not surprisingly, there's an appetite among a plurality of Canadians for more information from companies pertaining to data privacy. It's interesting when you look, so young Canadians say give us more, older want less. And I think the attitudes too depend on how well people feel they're informed about data privacy legislation and laws and the rights that they feel they have as Canadians in terms of the protection of their information. Perhaps not surprisingly, individuals find that privacy policies are too long, too full of legalese. I think what you find with privacy policies now is they're largely written by lawyers for lawyers. And if you speak to organizations about why it is that they're into lengthy terms of use right now, is really around those protections that they need to have around their activities, and more gets layered on as it relates to how it is they're speaking to their customers and to consumers about privacy. There is the other thing that's interesting about the findings is that there's trust amongst maybe a quarter of the individuals, even though they don't know about, they're not well informed about privacy laws, they believe that the privacy laws are there to protect them. So again, as is typical in research findings, there's often an imbalance as it relates to what people feel and what they're telling us versus what they believe is actually the case, and this is true as it relates to knowledge about privacy laws. The other thing that we found, and we delved into this when we asked the question about, well, if you don't read privacy policies and you don't read terms of use, well, what do you read? And if we think about this even ourselves, that there's strong evidence that Canadians care about the bottom line. So specifically, the more money that's at stake, or the longer the legal commitment, such as buying a mortgage, for instance, more likely people are to spend time understanding the legal terms and conditions of a contract. And it's interesting, too, where people spend more time looking at a gym membership agreement than the social media terms and conditions. And I think this is consistent with research that I've certainly seen, is that women tend to spend more time looking into details as it relates to, it could be terms of use, it could be really sort of documents that represent obligations that they might have to undertake. There's also, not surprisingly, people are more likely to say they read privacy policies in detail, or those that are more informed about data privacy laws. But this is very telling as it relates to, well, what should companies be doing as it relates to having conversations with individuals as it relates to their own privacy statements, I would say, online. The things that people are interested in, and this is, again, not terribly surprising, I would say, given especially what's happening right now, and the most recent being data breach being Saks and Lord & Taylor, although I didn't do a scan of the news today, and there might be another one, unfortunately, that might have occurred. But people want to know how it is that companies are keeping their information secure. So what is it that you're doing to make sure that when I'm giving you information that, that I know that there's the security means and measures that are in place. They're also concerned about choice, and they're concerned about transparency. And there's evidence, though, and this is the interesting one, that Canadians are less concerned about how it is that companies are monetizing their information, but also the sharing that takes place with third-party providers. I think given the recent events that have taken place in the news, perhaps that number would shift as people become more and more aware of what's happening with their apps and with applications and app developers and how information is being shared with third parties. So the thing that we found with the research is that it told us that, as well, that Canadians are willing to provide less sensitive information for their contact demographic information, and they're more willing to share their contact demographic or interest information and less willing to share locational type data with organizations. So what does this mean for us moving forward? And this was the key thing in us conducting the research and as large organizations trying to make the determination of what it is we should be thinking about as it relates to transparency. So where we arrived is really, and where we're going with this, is the need to deliver Transparency 2.0, to make sure it's more user-centric, to make sure that there is user-centric transparency as opposed to legal transparency. But we need to avoid over-transparency. So what does that mean? That means that we can't go the same way that we went with the privacy policies. We can't go the same way that we went with long and very drawn-out terms of use. There's no one-size-fits-all when it comes to transparency. And we believe that organizations are in the best position to understand what to be transparent about and know their customers best as it relates to the conversations that they need to have. But organizations are recognizing they've done a poor job of explaining value and benefits for data use. So people don't understand, or they're just coming to understand, what is that value exchange as it relates to the sharing of my information with a large organization, what they're going to do with that information, who they're subsequently going to share it with, and what I'm going to receive in return. The other piece around the research that we focused on, we looked at the findings, is that transparency doesn't necessarily mean more words, but it means the right words at the right time. The thing that I hate stating the obvious about with customers is to have the formal consent clause on forms, because customers hate reading them. So many companies are shifting their approach so that we put the customer at the center of everything we do and work our way backwards from there, not based, again, on legal and compliance. It's still a work in progress, but we feel the research has given us direction. So what are the tangibles that we're thinking about? And some of these things might resonate with you when you think about some of the ways in that you found information about diet and nutrition, for instance. What's been tossed around in the past, what we're looking at again now, are the effectiveness of nutrition labels. So when you used to sit and read that cereal box and say, wow, what's in this box? And what is it that I need to know as it relates to the contents and the nutrition around a cereal? So privacy nutrition labels. This is an idea that's been tossed around before, and it's one that's coming back again as it relates to the transparency conversation. The other thing that's being discussed is something like a layered approach. So having a corporate commitment, public disclosure, standard privacy policy, FAQs for those who want more, as I said, the privacy label and icons, and just-in-time notices. I'm just going to grab some water. Privacy needs to reflect the medium and the audience. And transparency needs to really, for transparency to be effective as it relates to privacy, it needs to look to not just the means of which we speak to customers through desktops, through call centers, through IVRs, through mobiles, looking at the Internet of Things. It also needs to speak to vulnerable groups. And what does transparency mean, and what does it translate to as it relates to those groups? The other thing, too, is that there needs to be a recognition of roles. So who needs to play a particular role as it relates to privacy and as it relates to education? And this is where, really, as the group of CPOs, when we look at the research and we look at what it's telling us, we say certainly organizations have a responsibility to bring that privacy conversation in a more meaningful way to consumers and to citizens. But also, there's a role for regulators and governments as it relates to educating. And there's also a role on the part of the individual. And I think that's an interesting conversation that we're having now, but I think also we'll probably hear a little bit more about this afternoon, is what is that role of the individual as it relates to their understanding of what's happening with their information, but also as what it means to them. If you think about privacy, and that's the difficulty about perhaps doing some research like this and talking about concepts like transparency, is that it's very contextual. It very much depends on the individuals, and it very much depends on a moment in time and what's important to us as it relates to our own individual information, but also those organizations that we're interacting with. Perhaps not surprisingly, I think where organizations need to move to as it relates to the conversation around privacy and transparency, and where we're seeing actually some of the larger companies respond to right now, is that greater justification around data collection. So what is the information that you're collecting about me? Why do you need it? And what it is that you're doing with it. The other thing is to use data judiciously. So when we talk about concepts like data lakes, when we talk about the various points of data collection that exist within an organization, is the need to use all of that data, to mine that data, to actually to bring in more third-party data. Does that really contribute to what it is that you're trying to accomplish, and does it really serve the purpose of the individual, be it a citizen or consumer at the end? Sometimes old-fashioned works, and that's the other conversation I think that's taking place in some organizations right now. So using surveys and direct collection from individuals rather than surveillance. And that is the other piece around this conversation of transparency that we want to bring to organizations around data collection itself. So really saying, what is that old-fashioned? And perhaps that's appropriate coming from someone who works at the post office, to say we need to go back to times when we think about what ways in which we used to collect data in the past. I think the other thing, too, that organizations are coming to understand, and some are there and some aren't, and I think it's really up to many of us to bring that conversation forward a bit more, probably aggressively, I'd say, is to invest in a good preference engine. Invest in something that's truly going to tell us what it is that individuals want, when they want it, and how they want it. And that's the other piece that I think where organizations are running afoul as it relates to transparency, is too much of this is still a surprise. And that's where privacy tends to intersect with the whole experience that they're having, and the intersection that they're having with a brand as it relates to transacting or purchasing something online. I think where organizations grapple with this too as it relates to these solutions is that it tends to be, these tend to be more expensive solutions. So building a preference engine in terms of being selective of the data that you actually mine, in terms of really spending time strategizing about how it is that you're going to use personal information of your customers. That takes time, and it takes money, and it takes really investments and resources that aren't just based in the technology, but that are also based in the people that are making decisions about how it is to apply the technology, but also how it is that the data should be really analyzed and also used at the end of the day. But I think that really around the bottom line, and that we found, and where large organizations like mine, and we're having conversations, is really for us to be much more proactive rather than reactive to citizens and consumers. And rather than us waiting for regulators to tell us what to do, rather than waiting for governments to legislate, really for us to take a little bit more of a leadership role and say, how do we need to define transparency? What does that need to look like as it relates to a framework for Canada? Because we truly believe that citizens and consumers expect this of us. Rather than us continuing to really collect more data, and for us to be able to have a hit and miss type scenario amongst our marketing team, but also the individuals within our large organizations that are using the information. So I think from us, and I think from the research, is that we found that it's not conclusive. I think where people expect transparency, we might not expect them to want it at the given time of which they're actually engaged in the transaction. And what I mean by that is that People will engage online with organizations and with brands. They'll go about their purchase. They'll be fine in knowing what it is that you're doing with their information. But if you infer something about them, if you target an ad to them based on an inference, based on something that you haven't collected about them, but you may be guessing about, that's where the whole issues of transparency and privacy intersect. And that's where organizations really need to go to figure this out. So I'll finish up there and say, I guess, too, that there are many organizations that are looking at this now. And it's something that many are doing well. There's some that aren't even looking at it at all, but are engaged heavily on data. And the conversation in Canada, I think, is very much something that is being embraced by not just groups like the Canadian Marketing Association, but many other organizations are coming together to really determine what it means as it relates to privacy in Canadians' digital lives. So I'll conclude with that. Thanks.
Thank you, Amanda. I would now like to invite to the stage Daniel Thériault, Canada's Privacy Commissioner, and Simon Hout, who is the Globe and Mail's senior media writer. They will have a conversation about policy and privacy in the digital world.
Thank you. Welcome.
Thank you.
We just met on the way up. I'm not sure if you saw. I shook his hand. That was the very first time I met him. Which is to say, I've been searching for information about him over the past couple of weeks, and you have a very small digital footprint.
You think so?
Well, I don't know. Is this intentional? Are you uncomfortable putting yourself out there?
If you look under Privacy Commissioner, I think you'll see some writings about me.
I think I was mainly looking for pictures of your kids. But you personally, are you personally comfortable putting yourself out there as an individual?
It's not a matter of being comfortable or not comfortable. My gray hair perhaps is the best explanation for the fact that I'm not particularly present on social media and so on.
All right, so perhaps it's a generational thing.
Yeah.
All right. I should start by saying that in January, of course, and the reason we're here, your office issued a draft of your online reputation position paper. You're taking comments until April 19th. So if you have any comments to make, you can direct them to his office, though I should warn you that information submitted to your office could become public under the Access to Information Act. So just be aware of that and the irony. So let's go back a bit. In 2014...
it's a question of balance.
A question of balance. It's a fine balance, and we will get into that. Thank you. In 2014, of course, the European Court of Justice ruled that information could be requested by an individual to be delisted from a search engine in cases where, and I'm going to quote, that information appears, having regard to all the circumstances of the case, to be inadequate, irrelevant, or no longer relevant or excessive. I should say, I should have begun by noting, journalist for the Globe and Mail, if all of our articles were subjected to the standard of being adequate and relevant and not excessive, well, you can judge for yourself. So with that in mind, in 2015, your office outlined that one of its strategic priorities over the ensuing 5 years, from 2015 to 2020, would be, quote, to help create an online environment where individuals may use the internet to explore their interests and develop as persons without fear that their digital trace would lead to unfair treatment, which made me wonder if you'd ever been on the internet. You asked respondents to weigh in on whether they believe that the positions outlined in the paper strike the right balance, as you said, between individuals' right to privacy and the right to free expression. So just let's begin with why Canada needs a so-called right to be forgotten in the first place.
I think that's the right first question to ask. We may get into the criteria and how the criteria in Canada might be a bit different from Europe's criteria in a minute or two, but I think the first question to ask is why. There have been laws on libel and defamation for decades, I think centuries, in common law countries and elsewhere. So what is it about technology, about the internet, which might warrant saying or concluding that these laws may no longer be sufficient to offer protection to reputation? And there are certain characteristics of the internet that I think change things considerably. Among these characteristics is the fact that information about individuals is much easier to find with the internet thanks to search engines and other functions. The information that is found will often be taken out of context. It is easily replicable, and it is very difficult to delete. All to say that information that went to reputation in the old, before the internet, that may be information known to a small circle of people, with the internet is now potentially known to many, many people out of context, and that information may be inaccurate and moreover may create real consequences for people. Reputation matters. If you post information as a teenager, say, or a young adult, a photo, comments, whatever, that goes to exploring the internet without fear that this will create harm for you. So you do that, say, when you're 18, and then when you're 27, you knock on a potential employer's door and you want to be hired, and what you wrote 10 years ago that may have no link whatsoever to what you think today is taken against you, and actually you don't get the job, or you don't get housing, or worst, you're humiliated because somebody has posted incorrect information about you on the net, and that leads you to being ridiculed, or worse. There are cases where humiliation could lead to people thinking about suicide. So there are real consequences to incorrect information being out there, to be seen by many, and that's the harm that we're trying to address. Is the solution, the best solution, that can be discussed at length. And a reason why we have put this out as a draft position paper is that we're pretty sure that there's a harm to be remedied here. And as a regulator, the tool I have to try to remedy the problem is the legislation that I have to monitor and enforce. But I'm extremely open to a discussion around what are the best remedies to find a solution and to protect meaningfully the reputation of individuals.
You've raised a number of just terrible red flags, especially as a parent. I'm immediately susceptible to your suggestion that my children could be be bullied or could have their words, their images taken out of context. At the same time, I will tell you, and you flicked at your gray hair, and I will indicate that I may have a few gray hairs, quite possibly because of my children. They are frankly far savvier online than I am. They seem to be far more capable of taking care of their own reputation online than I am. So it is possible, I'm just suggesting, that perhaps it's simply that we're in a transitional period, that you and I, the lumberers, or at least I, am not capable of handling my own online reputation. But 10, 15, 20 years from now, we will have generations that frankly know entirely how to take care of themselves.
Education is part of the solution for sure.
Right.
That's why among the recommendations that we've made in our paper is for provinces in Canada, of course, who are responsible for education, to build into school curriculum privacy education, digital education, so that individuals can know how to protect themselves, point one, and point two, can act responsibly online and not cause harm to others. Kids, it's true, know more about how to use new technology than older individuals. But when you actually survey and look closely at these issues, some of them, many of them think they know how to do that, but they don't necessarily do know how to do that. So I think education is absolutely part of the solution. But even a well-educated citizenry will not be able to protect themselves from serious harms. And I think the solutions, plural, include education, but also remedies when the harm is done.
You've mentioned specifically the harm that inaccurate information can cause. So is it primarily, and that raises the specter, frankly, of course, of fake news that we've been living with for the past couple of years, at least as a notion. But let me first ask, when you issued your draft report, you said you'd received, I believe it's 28 submissions from stakeholders outlining their views of this proposed right to be forgotten. Are there examples in Canada that you can cite for us where you see the need for these additional protections?
I've talked about the fact that there are consequences for employment, housing, and it could be even worse.
Right, but is there any case law? Can you cite anything, any particular examples?
We don't have, we haven't received complaints at this point, so it's difficult to give examples based on our own history and analysis. But cyberbullying would be a good example.
Isn't cyberbullying already covered?
It is covered, but it's an evolution. So 10, 15 years ago, there were no laws against cyberbullying per se. That the phenomenon still existed, and Parliament saw that there was a need to act, and they acted. Has Parliament covered all of the harms? I don't think so. So there are other harms, such as the ones I've mentioned. Do I have exact examples? We haven't received complaints, but you can conceive that there are harms short of cyberbullying that have not been the subject of legislation at this point, but for which reputation would still need to be protected.
We're not, obviously you've mentioned inaccurate information, but we're not just talking about inaccurate information. In some cases, we're talking about information that somebody believes should no longer be relevant. Somebody was in debt and they paid off their debts and they don't want to be seen as a debtor, primarily because they've lived a good and honorable life in the, say, 15, 20 years. Since they paid off their debts, why should their debt be the first Google hit that comes up? But really, we're talking about information that, for example, the Globe and Mail would be able to publish legally. It is legal and true information. Why would information that is freely available on the Globe website not be findable, not be searchable?
That leads me to the question of criteria. So in Europe, the European Court of Justice issued its judgment based on the criteria that you outline, including whether information is relevant and excessive. The position paper that we've published, it relies on the criteria in existing privacy law in Canada that I administer. There is no explicit right to be forgotten or right to de-indexing under Canada's privacy law, but there are two types of provisions which lead me to the position that there is a right to de-indexing. So bear with me. Point one, companies in Canada that collect and use and disclose information, personal information, must do that with information that is accurate, complete, and up-to-date. That's a current legal obligation that companies have. Not quite the European criteria. Excessiveness, for instance, would not be part of the law that exists in Canada. So for the most part, the criteria in Canada's laws are, I would say, more factual and objective accuracy, completeness. Whether it's out of date is more subjective, I grant you. So these are the criteria. And then how do we come to the view that companies have an obligation to consider the indexing requests? Well, they also are under an obligation under Canadian law to have processes. These processes are not defined in the law, but nevertheless, companies have an obligation to define processes to ensure that the substantive rights, including the right to process accurate, complete, and up-to-date information, are respected. So that's how we come to the view that there is a right to de-indexing under the current Canadian law federally. Now, to your point about relevance, it's not a criteria per se in Canadian law, but up-to-date is a criteria. So let's take your example of the person who was bankrupt, say, 15 years ago and no longer wants to suffer the consequences. I'll go back to the world pre-internet. In the world pre-internet, that person, after a while, would be able to try to develop business relationships, to live a normal economic life, and it would not be known that the person was bankrupt, except to very few people. With the internet, it may well be that the first thing that people will see when they do a Google search or a search under another search engine is the fact that 15 years ago the person was bankrupt. And the person may well no longer, may have a balanced sheet and so on and so forth, and should no longer suffer the consequences. So that goes to, we can debate whether that's a very harsh consequence or not, but it is a way in which the internet has changed things. Before, this fact was known to very few. Now it's potentially known to many, and this has consequences on people.
Sure, but it seems fundamentally undemocratic. I mean, why should it be, let's say somebody wants to start a business relationship and he has a bad credit history, and the usual checks on a credit history do not show it, but certainly decades ago he did. Why should the only people who are able to find out that information be the ones who can pay for a proper background check? I can go, or well, frankly, I can certainly go to Toronto Public Library, look up these news stories on somebody's bad credit history, but somebody without those resources may not have access to the same information and may, in fact, be putting themselves at risk because they don't have access to that same information.
You say that this is undemocratic. I think that's a bit harsh. I would go back to the question of balance. We have laws, for instance, in many Western countries, in Canada, among others, that consider that criminal records of individuals who have lived crime-free for a number of years should not be accessible to many because rehabilitation is a value that we promote in Canada and in many other countries. If that's true for criminal behavior, why not for somebody who was bankrupt 15 years ago and who has lived financially prudently since then?
So let me just ask, and I'm not sure if you've gotten into this nitty-gritty. I mean, most of the time we're talking about Google, big bad Google, and Yahoo, and I guess Bing. Anyone? Bing? Would be required to delist these pages. Would the Globe and Mail be required to, with its search function, be required to delist?
Here we get into the distinction between de-indexing or delisting on one hand and takedown on the other. If the information, if it was published lawfully, I don't think we're into a world where Google would need, the Globe and Mail or another media outlet would have to erase from its holdings or from previous issues of the newspaper information which was there correctly. So no to that with respect to media outlets.
But it might still be there, would I be able to find it on the search function of the Globe?
That's a good question. On the search function of the globe, on a search engine, if the information was neither accurate, complete, or up to date, I think under the position we propose that the search engine would have to de-index or delist. For the newspaper, we would have to look at whether we're closer to the core of freedom of expression, freedom of the press. These would have to be weighed in the balance.
Do you see a conflict between freedom of expression and free press, concepts that are enshrined in the Charter, conflict between the right to be forgotten and those concepts?
There's tension, as there is tension between many rights that are constitutionally protected, between privacy on one hand and freedom of the press and freedom of expression on the other. The courts arbitrate these tensions between rights all the time.
You would ultimately, I presume, then see this going before the courts.
It's likely going into the courts, yes.
Would this best be administered by search engines? I mean, at the top, we saw a poll that suggested that only 18% of Canadians would support search engines overseeing this. They would prefer the courts to oversee something like this, if in fact this right were passed into law.
So legally, you start with the proposition, as I've said, that companies, including search engines, we think, have an obligation to develop processes to ensure that substantive rights are protected. So you start there. They're the first port of call, so to speak. But it doesn't end there, obviously. So decisions would first be made by companies, including search engines. These decisions would then be potentially reviewed on complaint by my office or provincial equivalents, and some of them would end up in court, and the courts would ultimately decide. I'll say, and Peter Fleischer may have something to add on this in a few minutes or hours, that when I looked at the record on the application of the right to de-indexing in Europe in the past few years, that it struck me that most decisions that search engines make are upheld by data protection authorities or privacy commissioners, which goes to the fact that it may not be perfect. I get that it's not perfect, that private companies arbitrate in the first instance on the balance between rights. I get that. But there is an obligation, I think, under Canada's privacy laws. And when we look at the experience of search engines in Europe, most of their decisions are upheld, which means that they're doing a reasonable job of it. So I think it's to start with search engines or with companies raises questions, yes, as to whether this should be done by a court or an independent arbiter. Yes, it's an issue. But it provides a quick and ready remedy to a phenomenon and a harm that occurs because of the internet very quickly and can have very grave consequences very quickly. If we wait to file a brief in court on a libel or defamation suit and get a result 2 years, 3 years, 10 years if it goes to appeal, that's not an effective remedy. These remedies should continue, but part of our point is there should be remedies that are available more quickly and more readily, of course, subject to court intervention.
Are you not concerned with the fact that private companies would be more likely to delist more rather than less, because obviously they don't want to run afoul of the laws?
The history so far, Peter will tell us whether that has changed, is that in Europe at this point about 40% of requests are granted.
Right, 43% of requests are granted.
Yeah.
Sure, but no, but who's checking them and saying, oh, you actually overreached here? I mean, all of the...
That's an issue that for which I think the remedy of de-indexing needs to be looked at closely. So how are the interests of the press or others, the publishers of information, how are they taken into consideration in deciding whether to delist or not? I readily admit that there's something to look at there.
So it starts with the search engines. Your office would perhaps
Second port of call, probably.
Second port of call. Do you have the personnel for that?
This is something that's, again, done in Europe. They managed to do that. We'll use our resources based on priorities. If there's a need for more resources, we'll make a request to government. At this point, my understanding is that in Europe, this is not something that is overwhelming the equivalence of the privacy office.
Okay. I mean, I'm not saying it, of course, but cynics may say, oh, this is just an attempt to kind of beef up your office, expand the ranks. I'm not saying that.
I would go back to, and I ask the question of all of you and everyone in society, is online reputation something that is worth protecting? That's the first question.
I just want to, we've got about 5-6 minutes here. I just want to get your opinion on this. Google and others often suggest that the best analogy for these kinds of delistings is, and I mentioned I could go to the Toronto Public Library and find information. They often mention that, it's like going to a library. You can't look necessarily at the spines of books. There's no card catalog. You can start just pulling books off the shelves. I mean, that's essentially what delisting is. Is that a helpful analogy? Do you see that analogy? Is that valid?
Yeah, it's not a bad analogy. So let's use the analogy. What choices do we have? So ultimately, if privacy were to be protected fully, and damn freedom of expression for those who published or wrote the book would be taken out of the library. I think that's going too far. We're advocating delisting, making it more difficult to find information because the ease of access is one of the characteristics which creates the harm to individuals. So to take the book out of the library would be going too far. Not doing anything would not protect reputation and privacy sufficiently. We're left with the middle ground, which is not a perfect ground, but at least it seeks to balance the two interests at stake.
You've said it's not perfect a number of times. I mean, does that not make you uncomfortable?
What alternatives do we have? Is it really good for society that information, inaccurate information that may lead to humiliation and worse, cyberbullying, suicides, that we do not seek to find a solution to these problems?
Well, again, I mean, cyberbullying, I think we've already established, more or less has been taken care of. And inaccurate information. I'm not suggesting that the internet is a self-cleansing device, but certainly yesterday during the YouTube, as to pull an example, during the YouTube shooting, there was all kinds of inaccurate information flying around on Twitter and elsewhere, and Twitter took steps and. Because they understood that this kind of inaccurate information needs to be taken down. But that doesn't involve laws. It doesn't involve what some might see as overreach.
Well, you asked whether it's the right place for companies to delist, and now you're saying that social media companies have mechanisms under their own policies to remedy the solution. Which is it? So I think the solution includes companies, but does not stop at companies, hence the need for laws. It is insufficient to rely only on companies to do the right thing and to take information out from the search engines, social media, and so on based on their policies. We're governed by the rule of law, and many companies seek to act responsibly. But in a country governed by the rule of law, protection of individuals does not stop at companies doing the right thing. There needs to be law.
And so can you outline for us in our last couple of minutes what kind of legislative changes you might like to see?
Well, the first point is that, as I've explained, I think there are arguments under the current law for a right to delisting and take down to say that it exists under the current law in Canada. Now, I also recommended that Parliament look at this because I'm fully aware, one, of the fact that the mechanism is imperfect, but more importantly, that we're playing on the balance between two fundamental rights. I can use the tools I have, privacy law as it exists, to achieve the best balance possible, which is what the position is about. But I think it would be preferable from a democratic perspective if Parliament studied this issue and looked at what is the proper balance based on the fact that they're elected officials and may craft better remedies to address the problem. So I've said, point one, I think the remedies exist under current law, but it would be preferable for Parliament to look at this. And there's a parliamentary committee that actually agreed with me and recommended that government look at this and table legislation if they see fit. So if Parliament does not act, I think there is grounds under the current law for me to try to adopt this position as best I can, as balanced as possible. But the true solution would be, I think, for Parliament to look at this issue.
Mr. Terrien, I really appreciate you taking the time.
You're welcome.
Thank you.
I'd like to thank Commissioner Terrien and Simon for their interesting conversation. I'd now like to introduce our next conversation. This one is between two lawyers. Nervous giggles. I'd like to welcome to the stage David Fraser, who is an internet lawyer, technology and privacy lawyer and partner with McInnes Cooper, and Keith Rowe is a former student of mine who is now an associate lawyer with McCarthy Tétrault. Their conversation will be moderated by Esther Ankin, who's the ombudsperson for CBC English Language. Thank you.
Thank you.
Thank you. I think that was an excellent sort of setting the stage for the next logical kick at this, which is how do we make this work under Canada's charter? Mr. Terrien said that there are arguments under current law that the right to be forgotten and take down exist. It would be preferable to craft a remedy. The question is, how would it sustain a charter challenge? And my particular interest is how do we protect and how would this impact the practice of journalism and the freedom of expression? So I'm going to ask David to start to sort of set that constitutional framework, and we're going to have our David and Keith approach this from slightly different perspectives around where the right balance might be.
Yeah. Well, thank you. Thank you very much for the invitation to be here. I think this is going to be one of the big, significant, and defining issues with respect to privacy law and freedom of expression in the next couple of years. So, just in terms of setting the context, just to lay out kind of how the charter works in a situation like this. So, we have Section 2B, which guarantees freedom of expression, but that's not absolute. We have many cases in history that you can go back through where that expression right is attenuated or can be restricted because of Section 1 in our charter that allows rights to be restricted in a manner that are consistent with a free and democratic society. And that's based on something called the Oakes test that requires that it be prescribed by law, that it be a pressing and substantial government objective. There has to be a rational connection between the measures taken and the mischief that they're trying to address. Minimal impairment, which I think is where this issue, the rubber is actually going to hit the road, and then the final balancing between the impact on one freedom and freedom of expression and the privacy rights. And I think one of the challenges that we're going to have here in this particular question is the fact that Canada is different from Europe. We don't have a constitutionally protected privacy right in the same way that we have a constitutionally protected freedom of expression right. Privacy laws have been characterized by the courts as being quasi-constitutional, but that's not necessarily the same. And the courts grapple with this question of how do you strike the right balance? And the question is actually, it's a little bit academic until we have criteria in front of us to determine exactly what's being determined. And we have, for example, defamation laws have been upheld as consistent with charter principles. We have defamatory libel under the criminal code that was found to be constitutional, but only because the person saying the words knew that it was false and did it for intentional kind of harmful purposes. Hate speech laws have been upheld. So it all comes down to characterizing the mischief, what are we going after, and have the means chosen, are they appropriate and appropriately tuned to those sort of circumstances. And so I think one thing that we also have to bear in mind is that under our current privacy law, journalism is carved out. That our privacy laws do not apply to any information that's collected, used, or disclosed for journalistic purposes and for no other purpose. So Parliament already expressly recognized that they did not want our privacy laws to be affecting the practice of journalism. And I think one thing that's also worth noting is, so I've seen a number of right to be forgotten type cases kind of cross my desk. And in just about all of those cases, the content that's complained about is traditional media. It's stuff that's on cbc.ca, it's stuff that's on the Montreal Gazette, it's elsewhere. So it's not just the stuff that exists on people's blogs. And we have had, for example, instances where legislatures have tried to come in to deal with issues related to online reputation. So Nova Scotia passed the Cyber Safety Act in the aftermath of the death of Rehtaeh Parsons to deal with cyberbullying. And I challenged it in the courts. I called it a dumpster fire, and the court said it was a colossal failure because they did such a poor job at striking the balance. Now they come up with a new law. Maybe that will fix it, but that's yet to be seen. I think also fundamental in this question is looking at whose rights are engaged. Because if you have a situation where information that lawfully exists on the internet stays up on cbc.ca, but you're telling Google that they can't index it or they can't direct their users to it, you're engaging the constitutionally protected Section 2B rights of Google. Corporations have charter rights. You're implicating the charter rights of the journalists, the publishers, and the editors, the people who created that content. But you're also, and this is also often missed in the conversation, we have, as citizens, individuals, a charter right to receive information. And so all three of those need to be scrutinized pretty carefully to make sure that a proper balance is struck. And I think that when you have a situation that, well, as a starting point, I don't think that search engines are engaged in commercial activity in this sort of scenario. And I also do think that they're exercising a journalistic function when they're helping individuals find journalistic content online. So I think there should be out of the picture to begin with. But putting it through the sort of analysis, we have to go through the Oakes analysis. No matter what, it's going to implicate freedom of expression. We have an admission to that effect. And so is it something that's prescribed by law? And in the current legislation, it's probably too vague to be even considered to be prescribed by law, at least under the criteria that our courts use. Is there a pressing and substantial objective? And I think that's debatable. I don't think we've seen a massive lineup of people saying that they have problems, but there are people who have issues with this. It is notable that the only time that this comes to our attention is after this right has been fabricated in Europe, and now there's that notion, people become aware of it in Canada and want to exercise a similar sort of right. And then, so if we concede that there's a pressing and substantial objective, the question is it rational? Is this way of dealing with it the rational way of dealing with it? And even if you concede that it is, but where I said the rubber hits the road is going to be this question of minimal impairment. Do we hit the right balance in this sort of scenario where, for example, you have a situation, and it's akin to the library example, you have information that lawfully exists on the internet. You have a journalist who wrote the article, an editor who reviewed it, a publisher who allowed it to be there, somebody who determined at the time that it was newsworthy. Somebody decided to make those archives available on the internet. So somebody made the decision that there is value to the universe and to the publisher to having that content there. They decided to make it indexable on the internet. There's ways that publishers of online content can say, don't index this, keep it off search engines, or please index this. So we have content, they've said, please index this. And so they have the right to make that information available to other people. Google, as part of its business model, that's what it does, and it tries to determine relevance in terms of content and any other search engine. But you have a law that's saying that the intermediary cannot tell somebody that this information exists. Yes, they can find it by browsing the stacks in the library if they wanted to, or opening every book and going flipping through. But you have somebody in the middle who's being told legally, you cannot let anybody know this sort of stuff. And I have a challenge, I have a problem figuring out that that is minimally impairing in order to accomplish those objectives. Now, one can slice and dice, and as I said, it really depends on how you figure out this criteria. If you have a categorical exclusion that says, well, if it's a professional journalist who wrote it, well, then it's kind of considered to be newsworthy and we'll leave it there. Then you have a situation, I write a blog. I'm excluded from that. And so kind of where is this slippery slope? The Supreme Court of Canada in Grant and Torstar said the responsible journalism defense is applicable to anybody who writes. It's not just somebody who has a journalism degree. If I, on my blog, exercise that level of diligence that's referred to in that article, I have the benefit of that. And that was, I think, another example where freedom of expression and privacy and reputation collided, and the Supreme Court of Canada notched up freedom of expression rather than reputation. I think that's the tendency of where we're going. And then the final question is kind of have we struck, in fact, the right balance? Will this have a chilling effect? Will this have an impact on the ability of people to find information that they're looking for? And there is the possibility of two-tiered systems. I remember back in the olden days, before newspapers had all their archives online, going to the university library and taking CDs and putting them in a machine in order to get back copies of material. Now all that stuff is out there. Does that mean that content is really only available to the people who have the resources to go to the library or to sign on to a subscription service? They get the truth about somebody, whereas the ordinary kind of pedestrian Canadians don't. And so I think ultimately, the proof is going to be in the pudding, and we don't know the exact recipe of the pudding, but at least from all the different permutations and combinations, I don't think that we're going to see something that can make it through that sort of charter challenge.
So before we get on to Keith, where do you see the responsibility lying that would stay within the law for remedies to genuine need to manage? There must be some need to manage reputation.
Well, we have laws related to defamation, for example. So if the information is incorrect and misleading, that's defamatory. If it harms somebody's reputation and it's incorrect, that's defamatory. We have a whole body of case law out there. Yeah, it's cumbersome. It's expensive to access that sort of justice, but the law exists. And I can see somebody whose reputation is being seriously harmed who doesn't have the kind of deep pockets to go to court to look for a short circuit around that. But the challenge with this is information that was accurate and newsworthy at the time that it was put out there, somehow having a statute of limitations and somehow kind of expiring over time and ceasing to be relevant. And when you have so many different criteria, there was just a case out of the Irish courts where an Irish politician who ran on a family values petition tried to get the content from Reddit taken down, well, a link to Reddit from Google taken down. And the Data Protection Authority said, no, it's somebody's actual opinion that you're a homophobe. And then the District Court of Ireland reversed that and required it to be taken. Thank goodness, the higher court of Ireland kind of turned it back. But so a situation where you have a politician who just doesn't like being called a homophobe, using that right to try to get that content taken down.
Well, it's interesting because, of course, in my line of work, and I think Sylvia's here, her line of work, there may not be a lineup in the courts, and there may have not been too much down to the privacy commissioners, but it would be actually almost helpful if there could be a more precise criterion framework, because we face it all the time, right? And it is often about relevance. I'm no longer doing this, but you were at the time, and and our default, of course, is not to take it down or to de-index. And we'll get to the unanswered question before, I hope, which is, how do you delineate between a search engine that's Google and a search function that is the Globe or CBC? But I'm going to let Keith jump in here and present a slightly different perspective.
Thanks. So I want to start with the question that we often gloss over, which is, what's the charter actually for? Why do we have the charter, and what is it trying to do? And one of the reasons why we gloss over that is we now have a framework that tells us how it should be applied, and lawyers love frameworks, so we go straight to them, and we don't stop at why are we doing this in the first place. But when the framework was constructed, the Supreme Court had to actually ask the question, what's it for? Why are we doing it in the first place? And one of the answers is in the Oakes decision itself, and it's that there are underlying values that the Charter is intended to promote. And one of those values is respect for the dignity of human beings. There are other decisions from that era that also talk about the importance of protecting vulnerable people. And so, the Oakes framework is an analytical tool, but the question it's asking is, when interests come into conflict with each other, and these interests go beyond just charter rights, it's a broader conception of interests, how do we decide where to balance them or what the balance should be? And the guideline, the guideposts to that balance are these underlying values. Valuing human dignity, protecting the vulnerable in particular. So we start with the notion of privacy. So privacy, the word privacy doesn't appear in the Charter, but that doesn't mean that the Charter doesn't protect privacy. The Supreme Court has recognized, many times that privacy interests appear in a couple of different places in the Charter, partly under Section 8, which isn't so relevant in this context because that's more about search and seizure, but also under Section 7, which is about liberty, among other things. And the interest that's protected under Section 7 includes the right to a sphere of personal autonomy, a freedom to make decisions, a freedom to exist as a human being. And the link to that particular kind of freedom and what I would call civil privacy, that is, the control that an individual has over personal information about him or herself, has been recognized several times by the Supreme Court. Initially, this came up in the context of defamation in the Hill and Scientology case, among others. But it's been recognized repeatedly, and including in the United Food and Commercial Workers case, which we'll talk about more in a few moments. In fact, let's stick with it right now, because one thing I do want to take issue with is the idea that there might not be a pressing and substantial concern here. I think, first of all, as I read the United Food and Commercial Workers case, the Supreme Court's already acknowledged that there is a pressing and substantial concern. But even if that wasn't the case, I don't think it would be a hard hill to climb. We heard Commissioner Therrien talk about the kinds of harms that are potentially at stake. These are real consequences. And it's certainly within the realm of things that are worth thinking about as a policy perspective. That doesn't tell you what the answers are, but there are questions and problems to be addressed. But I do agree with you that minimal impairment is probably where the heavy lifting happens. That's usually the case in charter cases, and I think it's important to sort of recognize that minimal impairment isn't a straitjacket. It's a tool. It's part of an analytical framework that has a purpose. And it's a purpose that's driven towards values, which include protecting vulnerable people. So, the Supreme Court has recognized that the way minimal impairment has to be approached or considered is contextual. And there's more freedom for Parliament to balance interests when what it's trying to do is to protect vulnerable. And I think we can agree that in trying to protect reputation, we are talking about people who are vulnerable, at least some of the time. Now, there are also vulnerable people on the other side of the equation. And so, that's not an argument that cuts only in one direction. But what the court has said a couple of times, and in particular in the Irwin Toy case, is that really, when it comes down to solving these policy issues, finding the right balance, that is Parliament's job. It's not really the court's job. The court has a protective role to intervene when legislators get it wrong, but it's not at first instance up to the court to say, no, it really should have been this way and not that way. So if legislatures grapple with a real problem and they think about it seriously and they take the right interests into consideration and they include mechanisms that reflect those interests and that balance them in appropriate ways, the court's going to say, okay, you did your job. That law is just fine. It's certainly possible to get it wrong, but it's also possible to get it right. So if the first question is it possible to craft a right to be forgotten that would pass charter scrutiny, I think the answer is clearly yes, it's possible. The real question is when and how. So if we look at the cases where the courts have upheld restrictions on the freedom of expression, it's generally comes down to two factors. Was the speech in question harmful, and is the restriction proportionate to the harm? So, as I've mentioned, I don't think that demonstrating the harm is going to be a difficult hill to climb. The consultation submissions, the 28 submissions that were recently received by the Office of the Privacy Commissioner, talk about a number of them. I'm not going to go into detail, but I'll mention one in particular that sort of jumps out at me, and it's the pug meme case. For the sake of the person involved, I'm not going to talk about it in great detail other than to say that really what happened in this case is somebody posted a picture of an individual with a rare genetic condition, and other people took that image and repurposed it. And repurposed it in disrespectful and arguably humiliating ways. Is that defamatory? Probably not. It's not necessarily saying anything about the individual per se. It's hard to know whether existing law would provide a remedy for that. But it's an example of a situation where a real person, has to live with, some fairly unpleasant consequences of people taking information out of context and repurposing it. And there are other examples of people who really are facing the kinds of problems that Commissioner Terrier mentioned, difficulty finding employment, difficulty finding housing, all of those kinds of things. And if he hasn't received the complaints, they'll be coming because we know these things are happening out there. The submissions to the consultation also mentioned in particular, the particular vulnerability of young people. And it may be that, that's a special category that needs to be considered in some way. But we come back to the question of proportionality. And proportionality is always something that you have to, put it this way, you can't answer it in the abstract. You can only consider proportionality, when you're looking at an actual regime or a proposal, because, the real question is not, is it ever possible? It's, is any particular remedy actually striking the right balance? And you can only ask that question when you have the regime in front of you to look at. So the question then becomes, what safeguards are necessary? And what safeguards might we think about? So the European model that started this whole conversation includes a set of guidelines that have come out of what's called the Article 29 Working Party. That is as an organization, it's a group of the data protection authorities of all of the different member states. And so they got together and they thought about, okay, we've got this court decision, how do we implement it? And they came together, or they put together a list of guidelines and considerations. It's quite a long list that they say, as the data protection authorities, that they are going to consider when analyzing these cases. And you'll be happy to know that journalistic purposes is exactly one of the things that's on the list. So who published the information, for what purpose? It's a relevant question to ask. Other relevant questions include, was the subject somebody who plays a role in public life? Or was a public figure? Other questions are what is the information? Is it information that is sensitive? Is it information that is inaccurate? What is the actual harm or the actual risk of harm in the particular circumstances? And all of these things are factors that the Europeans have said are relevant to this analysis. And Canadian courts have said exactly the same thing. So I'll go back to the United Food and Commercial Workers case, and that was a case about the Alberta privacy statute, known as CIPPIC. And the particular case dealt with a complaint about unions photographing and videotaping people crossing a picket line, and then publishing that information. And people complained, and initially there was a ruling that this was a breach of the Alberta Privacy Act. And the Supreme Court actually struck down the act on the basis that the balance hadn't been struck properly there. So why in this case? Well, the court could have said, and this is just as an aside, some of you know that Barry Sookman was supposed to be speaking here, and I'm taking his place. This is a device he likes to use. He always likes to look at what the courts could have said. So since I'm sitting in his chair for him, I figure I'll use it too. The courts could have said that privacy never trumps freedom of expression. It didn't say that. The court could have said that the reason why the law is offside here is because it doesn't consider X, Y, and Z and set out particular factors. And it didn't really do that either. Essentially what the court said was they didn't do anything at all. And the response of the Alberta government in modifying the law was quite limited. It's an open question whether what they did was actually good enough, but so far no one has challenged it. But the guidance that shows up in the case, to the extent there is any, is exactly the same kinds of factors. It's what was the information. In this case, it was mostly public because it was information about what people were doing out in public view. And what was the competing interest? In this case, it was labor rights, freedom of association, which have long been recognized by the courts as being worthy of protection. So in that case, they said, because you didn't do anything to protect those legitimate rights, that goes too far. There are other cases that have gone the other way. There's a case that's it was actually decided under Quebec law because it's about the right to protection of the private life under the Quebec Charter. But it deals with commercial publication of photographs with or without the consent of the subject of the photograph. And in that case, the Supreme Court said the privacy right and the privacy interest of the individual portrayed in the photograph outweighed not only the interest of the publisher in publishing the photograph, but also the interest of the photographer in creating the photograph in the first place. So, there are cases where the protection of reputation and the protection of privacy wins out over freedom of expression. And I think I can stop there, frankly, because really what it comes down to is what are the guidelines going to be? What are the criteria going to be, and what are the conditions going to be? And frankly, I don't think we know the answer to that. There have been some proposals circulated. The draft position sets out some. The report of the parliamentary committee sets out some other ones. The GDPR has a new set entirely. All of these things are fair game to talk about what's the right solution. How, as a policy issue, do we strike the right balance? But if the question is, can we do this and will it survive scrutiny? I think the answer is, if you approach it in a sensible way and a way that is sensitive and responsive to the interests at stake, then yes, you can.
All right. a couple of things I'd like to clarify. When you're talking about what this law would cover, I'm going to go back to the question that seems to remain unanswered. And one is there an argument to be made that Google and other search engines actually do have a journalistic function, and that one of the issues around Facebook and what it's been doing is that it's not taking responsibility as a publisher, which it has become. And where will that line be? And would this legislation or set of rules also apply to the search functions that the traditional news organizations actually have, and would that stay intact? How do you square that circle?
Well, certainly, I'm of the view that it is a journalistic function. If an individual goes to Google to search for content that leads them to journalistic content, Google is acting as a proxy for the individual to get access to the journalistic content, and Google is also acting as a proxy for the publisher of that journalistic content in the other direction. And to say that because Google runs ads, they're engaged in commercial activity so that all of PIPEDA applies, I think it ignores at least some case law related to the State Farm decision in particular. It says you actually need to look at really what is going on here. And there's also the concern that I have in the back of my mind that if Google is engaged in commercial activity so that PIPEDA applies, it can't collect any information about anybody unless it gets consent in advance, because Canadian privacy law doesn't have the legitimate processing exception that European privacy laws do. So it's kind of in for a penny, in for a pound. You're not only slightly pregnant under our legislation. It's either you are or you aren't. And I think that's certainly something that needs to be strongly considered. But there may be content, other forms of content that don't fit within the journalistic exception. But can you put it on an intermediary to kind of grade all those sources to say, oh, well, this is this kind of search and that is that kind of search? I don't think this fits with the way kind of online search works.
Keith?
So I'll say that I think that under current Canadian law, Google acting as a search engine would not qualify as a journalistic activity. And I say that because for two reasons. First of all, in the United Food Commercial Workers case, the Supreme Court said in particular that the journalistic purposes exception is not a blanket exception that applies to everything that's out on the internet that might be public interest. It's not a proxy for the public interest in receiving information. But there is actually a test for what is journalism, and it's articulated partly in the Grant and Torstar case, and it's been restated recently in the Globe 24 Hours case, and it's a three-part test, and it says it's about the purposes of the entity. It's not about the ownership or the corporate structure or what their mission statement says, but it's about the purposes of the entity in publishing the information. And first of all, the purpose has to be to inform the community on issues the community values. Maybe Google meets that. 2, it involves an element of original production. Well, that's problematic for Google because Google is mostly just recycling existing stuff, not creating anything original. And 3, it involves a self-conscious discipline calculated to provide an accurate and fair description of facts, opinion, and debate at play within a situation. Now, there's a couple of pieces in there that are important. One that jumps out at me is fairness. Google's objective is not fairness, it's neutrality, and that's different. Fairness from a journalistic perspective involves actually making some attempt to get the other side and to provide context. And that's not something that Google necessarily does. And you can argue, is this the right definition of journalism? But this is the definition that we have in case law right now, and I don't think Google satisfies it.
Although you either misunderstood or mischaracterized what I said. Google is a proxy for the journalistic activity. It's an agent, as was defined and set out in the State Farm decision. I'm not saying Google is a journalist.
Okay, fair. I'll take that clarification. But I'm not sure that it matters in the sense that if,
The federal court has thought that it matters in the State Farm decision. And to the point that a significant amount of activity was removed from the ambit of PIPEDA. So I think certainly it's one of those gateway questions. So even if one were to concede, oh, okay, well, this exception doesn't apply, then you're still into the whole rest of the argument. with respect to the charter, with respect to interpreting PIPEDA as we have it today in this sort of circumstance? Is it properly defined by law? All those other sorts of things.
So I agree that there are lots of unanswered questions, and certainly the relationship between traditional journalists and Google and the ecosystem in which they operate, and the importance of that ecosystem to supporting the journalistic purpose is all, grist for the mill. It's all something that needs to be considered. But I think you did say a couple of different things. One is, does PIPEDA apply at all? And the exemption under the current journalistic purposes exemption applies based on the purpose of publication. It doesn't say anyone who republishes that information is covered by the same exemption. Now, one might infer that as a matter of statutory construction, that agency is enough to bring you within the ambit of the exception. But I don't think that necessarily follows. It's a debate that has to be, taken to its ultimate conclusion. That said, I go back to the purposive analysis. I think there is a difference between what the Globe and Mail, CBC, all the other journalistic organizations out there do, and what Google does. Google's activities support those, and they're valuable, but that doesn't mean, that doesn't mean that they're necessarily the same or that they deserve the same treatment. We certainly don't.
So sorry, in this discussion, are you suggesting that the charter rights of the Globe and Mail and the CBC aren't engaged with respect to their constitutionally protected interest in reaching readers?
I'm suggesting that they're engaged, but they're engaged in a peripheral way. I mean, first of all, let's take a step back. What kind of expression is actually being limited here? If we take the European model, the content doesn't come down, it stays up. So it's still on the source website. The content isn't actually removed from the search engine. The search engine can still serve that content up for any search string other than the name of the person. So the impact on the public's right to know and the impact on the journalist's ability to convey information to the public is impaired in a fairly minor way.
So I want to clarify here, because in my own, perhaps it's just me, but I'm still confused around, would this ever directly apply, could this directly ever apply to a news organization asked to delist? Or, so the Globe and Mail, the CBC, CTV, could it ever apply to them? Could there be a process by which they would be asked to delist and take down? Well, we haven't even gone near takedown. Can you foresee that as part of?
You mean taking down from the search function the Globe and Mail or the CBC website? I can't imagine in a million years.
So, I mean, people can always ask.
They do. Trust me, they do.
But I go back to the deliberations of the Article 29 Working Party in Europe, and they said, the court left open the question of how this might apply to other organizations. So they said, well, okay, we're only interested in search engines. And by search engines, we mean the big search engines. That doesn't answer the question legally. It just says that as administrators, as the people responsible for responding to these complaints and policing them, they're not interested in policing against your website itself. Things can change. And one might imagine, the GDPR, for instance, does change this. The GDPR expands the right to cover erasure, and it applies to all data controllers. So to the extent you're a data controller, unless you fit within one of the new criteria that the GDPR sets out, it would apply to you. Mm-hmm. What model will we adopt in Canada? I mean, that's a policy question. These are choices to be made.
Now, I know you're legal experts, but you've dealt with journalistic issues before. Can you think about some of the ways the practice of journalism on the front end, whether it's around informed consent and what that might look like, could change that would sort of mitigate some of the issues at the other end? Any thoughts on that?
Sure, yeah, no, absolutely. And I think that in this big conversation, in terms of practicalities, I think
that's where my head's going.
There are a number of things that we can think about. Is that what is the utility of publishing somebody's name in connection with an arrest or in connection with something else, particularly for a relatively minor crime? You might want to report that an arrest was made, but really doesn't matter. I've been dealing with the issue with respect to social media, the use of social media to search for missing people. And the police routinely use it because it's a great tool to reach a whole bunch of people. But then when the person is found, and usually the person is left or is ducked out of society because of stressors and things like that, they come back and there's this massive exhaust of stuff citing their name with a whole bunch of people speculating about it. And I was speaking with a police officer in the UK who said they've stopped using the person's last name because you have the same utility and there's no, that way it doesn't follow them around. And I think that there's some utility to thinking about that in news reporting. The identity of the person, how important is it?
Yeah, and it's a great question that you raised because, of course, the value for journalists has always been, it's always been exceptional not to name a person. But in fact, I've certainly, in my own thinking, drifted that way in the last couple of years around. And I did adjudicate a case where the family went to the police. It was a mental illness question. It was in Ottawa, and it was certainly in the public record. And then as this person was going through recovery, was totally stressed. And so the picture and the name was removed on my suggestion because it only seemed logical. Right?
Yeah, and that's, it's consistent with the approach that has been taken in a number of other contexts, in particular in the courts. Courts have struggled a bit with how to balance the open court principle with the interests of the people who are named in judgments. The matters that come up in court can often be very sensitive, especially in family law cases, but criminal cases and even in civil cases, often the details that may be discussed are at best embarrassing and possibly worse.
And for years, employment insurance decisions have not named the parties. You get the decision, you get the logic, you get the reasoning, but really it has nothing to do with who the person is. Yep.
Yeah, so I think that's a great principle. The other thing, of course, is the traditional values that journalism has always sort of stressed of fairness and objectivity, and
fairness and balance.
Well, fair enough. Okay. To the extent that those are factors that are relevant considerations in most of the frameworks that would be applied here, when you're doing that, you're aligning with what the outcome is likely to be.
It could mitigate a fair number of the sort of lower level cases. Pardon me for keeping on looking at my watch because the clock is completely obscured by
it says 0.
My line of sight.
Blinking red light.
We're out of time. Is that right? Looking at Natalie. Thank you very much.
Thank you.
Thank you.
Thank you. In my line of sight, I could see like the corner.
Well, I can barely see.
I'd like to thank David, Keith, and Esther for that interesting conversation. We've now reached the coffee break. I'd invite the guests to take coffee at the back of the room. Reconvene back here in 10 minutes. Thank you.